Hello everyone, welcome to UPSC Warriors by Unacademy. My name is Monica and this is Class 6 on Indian Polity. So far, we have discussed about Constituent Assembly, Preamble. We have discussed important articles starting from article number 1 to 4. This session is continuing that only, and here we are going to discuss part 2 of the Constitution, that is article number 5 to article number 11. Part 2 of the Constitution deals with the question of citizenship, and we are going to cover that. So, before I begin with the session, let's discuss the plan for polity. What we are doing here is this is a series about important articles of the Constitution. We have already discussed 4 articles, and today we are going to discuss from Article 5 to Article 11. We also discuss PYQs on this channel. We also discuss Supreme Court judgments associated with various articles, and this is how we proceed. We in this channel we make sure that you enjoy the benefits of the session, which helps you to cover prelims as well as mains questions. We also try to include current affairs in the session. So this is what plan for polity is. Moving forward, before I begin with the topic of citizenship, I need you to know that a country becomes a state if it has 4 important elements. The elements for a country to become a state includes sovereignty, territory, population, and government. The first element is sovereignty. A country should be free from external control. India has the word sovereignty mentioned in preamble, which we have already studied. India is declared as sovereign, socialist, secular, democratic republic country. Sovereignty is one of the key element for statehood. So India has sovereignty, which is mentioned in the preamble itself. The next element for state is territory. This has been already discussed in part 1 of the Constitution, Union and its territory. So we have discussed the aspect of territory as well. The third element for a state to be called as the third element for a country to be called as state is population, which could be interpreted as citizenship. And this is what we are going to discuss today. This is mentioned in part 2 of our constitution, citizenship. Hope you are appreciating the chronology here because the constitution starts with preamble, which ensures that India is declared as a sovereign nation. Moving forward, the next element for a state is territory, which is mentioned in part 1 of the constitution because a state needs to have a territory, an area. Then the third element for a state is population. A state should have its own population, which they call its citizens. So part second of the constitution deals with citizenship, and the rest of the constitution deals with formation of government and the rights and duties of these citizens. So that is what the rest of the constitution includes. So 4 elements of state is what is embedded in our constitution itself. Here we are going to discuss about this element of citizenship or population. Before I begin with the session, I have an announcement to make, which is about the batches that has been ongoing. An academy has come up with a Liberty badge for students who are preparing for UPSC 2026. The batch is in English. The next batch is Pathway for 2025 aspirants. This batch is in English. And one more batch for 2 years program, Arambh batch, which is for 2026 aspirants, and the batch is again in English. So these 3 are the batches which you can opt for to make better UPSC journey. We also offer Iconic subscription, which includes live mentorship program, offline recorded classes, doubt clearing sessions, answer writing sessions, and much more. So you can enroll in these classes using my code MM05. You can use this code to avail discount. if you are interested and if you are a serious aspirant of UPSC. Now, coming back to our topic of citizenship, we have ensured that a state has all the four elements. Population element is dealt with part 2 of the constitution, which is citizenship. We'll start with the class by definition of citizenship, what citizenship means. Simply speaking, citizenship is a legal status which has been granted to the members. It is a legal status by virtue of which you get certain rights and you need to fulfill certain duties. It's kind of a trade-off where you get certain rights as a citizen of a country and you need to fulfill certain duties as a citizen of a country. So that is what definition is. It is a legal status which gives you certain rights and certain duties. The citizen of a country needs to fulfill duties. Now, if we need to elaborate furthermore, you can discuss about the type of people where one category is citizen and the other is called aliens. People are citizens of a country or not a citizen of a country. So we can divide them on the basis of citizens and aliens. This category is further classified into friendly aliens and enemy aliens. So the chart is people are categorized under two heads, citizens and aliens. Aliens are further categorized under two heads, friendly aliens and enemy aliens. Enemy aliens are people belonging to country which is at war with India. So those people are called as enemy aliens. Friendly aliens are other than these enemy aliens are called friendly aliens. And apart from it, there is one more category called citizens. So Article 5 to Article 11 of the Constitution deals with citizenship, who will be called as citizen of India. But the interesting thing to notice here is the Constitution mentions just the aspect of citizenship at the commencement of the Constitution. The commencement of the Constitution date is 26th January 1950. So it deals with the provisions as to who will be the citizens of India approximately at the time of 26 January 1950. Apart from it, the Constitution mentions that Parliament will be the body in charge to decide on who will be the citizen of India afterwards. Similarly, has been done in the Constitution. Article 5 to Article 11 deals with the citizenship status of people at the commencement of the Constitution only. Parliament has come up with an act called Citizenship Act 1955, which deals with further aspects of citizenship. So the entire chapter of citizenship has been covered under two heads, one by the Constitution and other by Parliament. The aspect which Constitution covers is about the commencement of the Constitution and the citizens there present. Apart from it, the rest of the things are handled by the law of the Parliament called Citizenship Act 1955. So this we need to remember. Okay, let us see the articles related to part 2 of the Constitution is Article 5 to Article 11. We'll discuss articles one by one. Then Indian Constitution doesn't follow dual citizenship. It follows single citizenship. What does this mean? India has dual polity, which means that we have government present at union as well as at state. But we follow single citizenship. That is, we don't accord our citizenship on the basis of state. We don't have citizen of Madhya Pradesh, citizen of Gujarat, citizen of Chhattisgarh. We have citizen of India. We only follow single citizenship, that is Indian citizenship. There are some countries who follow dual citizenship. Dual citizenship as in they accord citizenship on the basis of states or provinces. The country which I'm talking about is USA and Australia. They follow dual citizenship. On the other hand, countries like India and Canada follows single citizenship. We have dual polity. We have government at center and state, but we don't accord the citizenship status on the basis of state. We follow single citizenship. So this is one thumb rule which we need to remember. Now, I need to elaborate on the word dual citizenship one more time. We have understood so far that center and state citizenship comes under it. But there is one more meaning to it. Dual citizenship also covers multiple citizenship of countries. What I mean by this is, for instance, you can be a citizen of USA as well as you can be a citizen of UK. At the same time, you can be dual citizenship of you can have dual citizenship of two countries. India doesn't have center state citizenship. We only have Indian citizenship. We also don't allow multiple citizenship of country. If you are member of some other country as well, if you are a citizen of some other country as well, from that day onwards, you don't have citizenship of India. We don't follow dual citizenship in any form. Either it's center state citizenship or the citizenship of multiple countries. USA follows both of these citizenship. USA has center state citizenship as well as USA allows someone to be having multiple citizenship. So we don't follow that. But UK case is an interesting one because UK doesn't follow this citizenship. It has only one citizenship, that is the citizenship of United Kingdoms. On the other hand, it allows its members to have multiple citizenship. So here we need to understand that when it comes to having center state citizenship, UK doesn't have, UK has single citizenship. But when you mention dual citizenship in terms of having multiple citizenships of different countries, UK allows that. So dual citizenship has two meanings. India doesn't allow either of those. This is what we need to remember. Canada doesn't have center state citizenship. Like India, it also follows single citizenship. Hope this is clear so far. Now moving forward. Okay, Simmu Goldsmith has said it right. Article 9 deals with single citizenship. So this is the question which I have already discussed in the previous slide. The question is, Indian Constitution borrows the idea of single citizenship from where? We borrows the idea from UK. Whereas UK permits to have dual citizenship. Here the meaning of dual citizenship is multiple countries. It is not about center state citizenship. That is why it could be confusing for you. We have followed the idea of single citizenship, that is not according citizenship as per center state relation from UK. But UK allows dual citizenship because this dual citizenship is different from what center state citizenship is. It is about holding the passport of multiple countries. Okay. Now, why we inclined towards single citizenship and didn't opt for double or dual citizenship? The reason is pretty straightforward actually. India was already a diverse country. We have our divisions there and then. But if we divide ourselves on the basis of citizenship further, it would be harmful for the nation. The country is still in the process of making, so it is the wisdom of our constitution makers to opt for single citizenship. The simple reason is we don't want us to be divided further. And that is what the reason here is. State may discriminate in favor of its citizen. Here state means provinces. Provinces can discriminate in favor of its citizen. They can go for giving multiple rights, which can create a feeling of exclusion among rest of the members. It can promote regionalism as well. and it can go against fraternity, that is brotherhood and unity of the country. So in a nutshell, we don't want us to be further divided. That is why we opted for single citizenship. Now we'll discuss articles one by one, starting from article number 5. You can see part 2 of the constitution, and the name of the part, it is citizenship. I'll use red pen here. Okay. So article 5 will read the text of the article and then we'll try to understand what it is saying. The text is this: at the commencement of this constitution, every person who has his domicile in the territory of India. Okay, there are few words which we need to understand. At the commencement of the constitution was commenced on date 26th January 1950. So at this date, who will be the citizen of India? This is what the Article 5 mentions. At the commencement of this constitution, every person who has his domicile in the territory of India. Again, another word, domicile. This word means permanent residence or permanent home. Okay. So, on this date, a person who has his permanent home in India, along with that, certain few conditions need to be followed, and then that person could be accorded the citizenship of India. So, having permanent home in India and who was born in the territory of India, he was born in India, either of whose parents was born in the territory of India, either he is born in India or either of his parents are born in the territory of India, or who has been ordinary resident in the territory of India for not less than 5 years of the period, which comes out to be year 1945. So he has permanent home in India. He is born in India, or either of his parents are born in India, or he has been residing in India since 1945. So that person would be given the citizenship of India. This is what Article 5 mentions. Article 5 talks about, entire constitution talks about the citizenship status at the commencement of the constitution. We'll remember this date because this is the date where commencement happened, and then we'll decide who will be the citizen of India. So Article 5 clearly explains anyone who has permanent home in India and who is born in the territory of India, or either of his parents are born in the territory of India, or he's been living in India from 1945 onwards. So 5 years period is mentioned, then he'll be accorded the citizenship of India. This is what Article 5 mentions. Hope it is clear so far. Now we'll move to article number 6, which talks about the citizenship of people who have migrated from Pakistan, because we had a partition at that time. So it talks about rights of citizenship of certain persons who have migrated to India from Pakistan. So who will be given the citizenship of India in this case? This article discusses. So there is a cutoff date which is mentioned in the article. The date has been highlighted in the slide itself. The date is 19th July 1948. This is the date in question. So people who have migrated to India from Pakistan, because we have independence with partition. So partition happened and some of the people naturally must have migrated to India. So their citizenship status is dealt in this article. Notwithstanding anything in Article 5, notwithstanding means in spite of anything written in Article 5, a person who has migrated to the territory of India from the territory now included in Pakistan, it talks about the territory which was part of India but is now a part of Pakistan, shall be deemed to be a citizen of India at the commencement of the constitution if following conditions are met. So it talks about who will be the citizen of India if the person is migrated from Pakistan to India. So first is he or either of his parents or any of his grandparents was born in India as defined in Government of India Act 1935. The first condition is if the person, his parents or grandparents are born in the India which was mentioned in Government of India Act 1935. For simpler reasons, we can assume that it talks about undivided India. So wherever it is mentioned as India as defined in Government of India Act 1935, you can imagine undivided India, that is India before partition. So if the person is born in India, undivided India, or his parents or his grandparents were born in undivided India, and he has migrated to India, he can be accorded the citizenship. Pretty straightforward. Then then there is a deadline also for this respect. So we'll discuss the second clause now. In case where such person has so migrated before 19th July 1948, if the person has migrated before this date, he has been ordinarily resident in the territory of India since the date of his migration. Okay, so now he has migrated to India, but the date is 19 July 1948. So if he has migrated before this date, then he can be accorded the citizenship of India. If he has migrated after that, then there is one more condition which he needs to fulfill. In the case where such person has so migrated on or after the 19th July 1948, he needs to be registered as citizen of India by an officer which has been appointed by Government of Dominion of India, because India was Dominion at that time. So if he has migrated after 19 July 1948, then he needs to be registered with an officer appointed by Government of Dominion of India. Then he'll be accorded the citizenship. So it talks about a deadline which is 19 July 1948. On this day, the permit system between India and Pakistan came into existence. Permit system means now that we are two different countries, we need to have some restrictions on the movement of people. And that permit system was implemented on 19 July 1948. And that's why this date acts as a cutoff date. So Article 6 talks about people who have migrated from Pakistan to India. So if they are born in undivided India, they can have the citizenship. If they are not born in undivided India and they have migrated on this date, before this date, then they can have citizenship. If they are like afterwards, they come after this date, then they can be accorded citizenship if they are registered with an officer appointed by Government of Dominion of India. So this is what the constitution talks about. A lot of this detail became irrelevant because now we don't discuss about the people migrating from Pakistan according their citizenship. So this has become obsolete, but for the sake of coverage, I am discussing these articles. Moving forward, we'll talk about article number 7 now. Article number 7 is titled as Rights of Citizenship of Certain Migrants to Pakistan. There might be some people who have migrated from India to Pakistan and they might want to come back. So their citizenship status also we need to discuss. So it also has a cutoff date. The date is 1st March 1947. So it starts with, notwithstanding, that is, in spite of anything in Article 5 and 6, a person who has, after the first day of March 1947, migrated from the territory of India to the territory now included in Pakistan shall not be deemed to be a citizen of India. It talks about a person who has migrated to migrated to Pakistan from India will not be a citizen of India, except there is one condition. Provided that nothing in this article shall apply to a person who, after having so migrated to the territory now included in Pakistan, has returned to the territory of India. It talks about a person who has went to Pakistan and then came back to the territory of India. Now, for such an instance, we have a deadline set in under Article 6 itself, which is 19th July 1948. So it mentions that clause of Article 6 that we need to process those people under Article 6. This is what Article 7 talks about. It talks about citizenship status of people who have went back to Pakistan and then came back to India. So this is what the case was. Again, it doesn't make much sense now, but our constitution has this article, so we need to discuss that. Now discussing article number 8, which talks about people residing outside India. It talks about persons of Indian origin who is not in the territory of India, not in the territory of Pakistan, but they are outside these territories. So who will be accorded the citizenship? This is what the discussion is about. It's a pretty simple rule. The person needs to be registered as a citizen of India in Indian consulate. That's the simple clause which we need to discuss. Okay, let's start reading the article. Notwithstanding anything in Article 5, any person who or either of whose parents or any of whose grandparents was born in India as defined in the Government of India Act 1935. It talks about undivided India. So, either the person was born in India, his parent or his grandparents were born in India, and who is residing in any country outside India will be considered as a citizen of India if he has been registered by a consular representative. If the person has registered himself in the Indian consulate, then he will be considered as a citizen of India made by him thereof to such diplomatic or consular representative, whether before or after the commencement of this constitution, in the form and manner prescribed by the government of the Dominion of India or the government of India. So the simple condition is, if you are a person who is born in India, either of your parents or grandparents are born in India, but you are not residing in India at the moment, and you are not residing in Pakistan at the moment, so for that matter, you need to get yourself registered in the Indian consulate, and that is the pretty much the process for citizenship at that time. So this is what Article 8 mentions: right of citizenship of person residing outside India. So Article 5, 6, 7, 8 talks about citizenship status at the commencement of the Constitution. Article 5 talks about at the commencement of the Constitution. Article 6 talks about people who have migrated from Pakistan. Article 7 talks about people who have came back from, who have returned to Pakistan and then came back again. So it talks about their citizenship status. And Article 8 talks about people residing outside India. Now, Article 9 discusses about single citizenship. Article 9 says that if any person or any individual has voluntarily accepted the citizenship of a foreign state, then from that day onwards, he is no longer a citizen of India. So, no person shall be a citizen of India by virtue of Article 5 or be deemed to be a citizen of India by virtue of Article 6 or Article 8 if he has voluntarily acquired the citizenship of any foreign state. So, this mentions single citizenship. Article 10, I hope Article 9 is clear. It simply talks about if you accept the citizenship of some other foreign state, you are no longer citizen of India. Article 10 talks about every person who is or is deemed to be a citizen of India under any of the foregoing provisions, that is provisions mentioned in 5, 6, 7, 8 of this part, shall be subjected to provisions of any law made by the Parliament, continues to be such citizen. So it talks about Article 5, 6, 7, 8 talks about citizenship status. So if you have given citizenship status, and until and unless a parliament makes a law on it, you will continue to be a citizen of India. This is what Article 10 mentions. It mentions about the continuation of citizenship. So until unless parliament decides otherwise, you will be citizen of India. That is what Article 10 mentions. Here the power to decide on the citizenship relies on parliament. The same thing has been mentioned in Article 11 as well. Nothing in the foregoing provisions of this part shall derogate from the power of parliament to make any provision with respect to acquisition and termination of citizenship and all the other matters relating to citizenship. So what constitution does is it mentions that who will be the citizen of India at the commencement, and it gives power to parliament to decide on who will acquire the citizenship of India and who can terminate the citizenship of India. So it gives the power to parliament to decide on the status of citizenship. Similarly, Parliament has come up with Citizenship Act. So Parliament has come up with Citizenship Act 1955 to mention provisions of acquisition and termination of citizenship with respect to India. This act has been in news for year 2019 amendment, because this act has amended and it has given certain citizenship rights to people coming from countries like Pakistan, Afghanistan, and Bangladesh. So we'll discuss that also, because the amendment of Citizenship Act of Citizenship Amendment Act 2019 has been controversial. So we'll discuss that also. But here we'll need to know that Parliament has the power and Parliament has used the power and came up with this act. So we'll talk about acquisition, what are the manners in which you can acquire the citizenship of India, and we'll talk about what are the ways to terminate the citizenship. Let's talk about acquisition first. The Citizenship Act of 1955 talks about 5 ways through which you can acquire the citizenship of India. The 5 ways are: the first one is birth. We have seen that Constitution also uses this word a lot. For person who is born in India, for person whose parents are born in India, for person whose grandparents are born in India. So we give citizenship based on birth. We give citizenship based on descent: father, grandfather, mother, grandmother. So we give this citizenship on the basis of descent also. Then there are three more provisions of acquiring citizenship. The next one is registration. For someone who is in relation, for example, if someone gets married to a citizen of India and the person has citizenship of a foreign country, then that person, after fulfilling certain criteria, can become a citizen of India through registration. We can register that person as a citizen of India. So the catch here is, for you to be registered as a citizen of India, you need to be in relation with or in connection with a person of Indian origin. That is what the criteria here is. The next way of acquiring citizenship is through naturalization. Naturalization applies to people who comes from foreign territory and have no past association with person of Indian origin, or in the past has Indian passport. So that is what naturalization deals with. It accords citizenship to people who comes from foreign land. And the next is incorporation of territory. India has acquired various territories, for example, Puducherry. Then we have accorded citizenship, Indian citizenship to people of that territory. So this is one way of dealing with incorporation of territory. Also comes with deciding on who will be the citizen of India. So these are the 5 ways through which we can acquire the citizenship of India. The first one we'll discuss one by one, starting with birth. Now, one more thing to notice here is Citizenship Act 1955 has been amended multiple times, and the number of times it has been amended is large. But we'll discuss the important amendments. First amendment came in the year 1986 and it restricted the citizenship based on birth. Initially, India was a new country and we were giving away citizenship very easily. Then we restricted the citizenship law because we were witnessing population explosion. Also, giving citizenship this easy put on burden of governance, because we want our people to have better quality of life. So that's why we restricted this citizenship allotment. In the amendment of the year 1992, we made this law gender inclusive, because when it came to the clause of descent, we mentioned that if a person whose father is of Indian origin or has Indian citizenship can become the citizen of India by descent. Now, this is not gender inclusive because it gives citizenship on the basis of the citizenship status of father. What if mother is the citizen of India, father is not a citizen of India, and the child wants to be the citizen of India? Then how are we going to decide? So we made the law gender inclusive in the year 1992, where we neutralized the term and we replaced the word father with parent. So either of the parent can be citizen of India. The next amendment came in year 2003, which restricted the citizenship for illegal migrant. The person who is an illegal migrant and has entered India through illegal means is not allowed to have citizenship. That is what has been mentioned in 2003 amendment. 2005 amendment talks about overseas citizen of India. So this is what another crucial amendment looks like. And in the year 2019, as I've mentioned, we'll discuss it more in detail, because this citizenship amendment gives citizenship to countries on the basis of religion. It gives citizenship of people belonging to those three countries on the basis of religion. So that we'll discuss. So let's discuss the acquisition of citizenship one by one. We'll discuss on the basis of birth. So we need to remember this timeline, because at the commencement of the constitution, we were giving citizenship irrespective of nationality of parents. If the person is born in India and the nationality of parent is not a concern, we'll give him citizenship on the basis of birth. And this continued till 1st July 1987. Remember the Citizenship Amendment of 1986? It made the citizenship restrictive based on birth. So we restricted the citizenship. So this went for like, this is a timeline where we accorded citizenship on the basis of birth irrespective of nationality of parent. Then we made the law more restrictive, and what we did was, after 1st July 1987 to 3rd December 2004, either parent is citizen of India. If the person is born in this country and either of the parents should be citizen of India, then only we give this person citizenship. So that is how we made the law restrictive. Either parent is citizen of India. We added one more clause. Initially, it was whosoever is born in this country will be citizen. Afterwards, we made it restrictive and we added one more criteria, that either of your parents should be citizen of India. After 3rd December 2004, we added one more criteria where we mentioned that both or either of the parents should be citizen of India, and the other parent, if the case is if both of your parents are citizen of India, then, and if you are born in India, you can be citizen of India. But if one of your parent is illegal migrant, then you will not be the citizen of India. That is how we made the law more restrictive. Now, if you remember the timeline of amendment, you will see in the amendment year of 1986, we made the birth criteria restrictive. In the year 2003, which was mentioned in the timeline, we made the criteria of illegal migrant. So this is what you can see here. 1986 amendment, the deadline was 1987 because the act mentions the deadline and it needs to be afterwards. So 1987 deadline, and after 2003 amendment, the deadline is of 2004. So this is how you can remember these dates. You don't need to remember all these exact numbers, but have a rough frame or rough idea in your mind so that you can eliminate options better, or you can understand the mind that or the thought process that went behind these decisions. Okay, the next criteria is we allocate this acquisition of citizenship happens on the basis of descent. Descent means that the person is not born in India, but his parents, his or her parents are of Indian descent. That is, they either have the citizenship of the country or they are part of the citizenship. So, okay, it again starts from 26 January 1950, the date where commencement of the constitution happens. And the next deadline is 10th December 1992. So if you remember the amendment, we have made the law gender inclusive in that year. So this timeline, if you if a person is not born in India, but his or her father is a citizen of India at the time of his or her birth, then that person can be accorded the Indian citizenship. Again, it talks about citizenship of father. The term should be parent. So we corrected that in the year 1992, and till the date 3rd December 2004, we made the law gender inclusive, where we replaced the word Father with parent. If either of his or her parent is a citizen of India at the time of his or her birth, then the person can be accorded citizenship by descent. Moving forward, we added one more criteria after 3rd December 2004. We If the person is born outside India, then his birth needs to be registered with Indian consulate within 1 year. So additional criteria was if the person is born outside India and either of his or her parent is an Indian citizen, then what the parents need to do is they need to get the birth of the child registered with Indian consulate within 1 year. So that is what the additional criteria is, and that is what we still follow. So these are the timelines for according citizenship by descent. Now the third part talks about citizenship by registration. We need to register people as citizen of India with the central government. So central government can register persons as citizen of India. The term we need to understand here is person of Indian origin. These are people who have some sort of relation or have some history with India. Either they could be citizen of India at some point of time, or their parents, their grandparents were citizen of India. So those people with Indian ancestry is called as person of Indian origin. So for you to be registered as citizen of India, you need to understand this word person of Indian origin. So people, person of Indian origin and residing in India for 7 years can get themselves citizenship through registration. If you are person of Indian origin, meaning that you were a part of citizenship program of India, or your parents or your grandparents were citizen of India, or you have some history of Indian ancestry, then and if you reside ordinarily in India for 7 years, then you can register yourself as Indian citizen. There is one more criteria. There are many criteria for yourself to be registered as Indian citizen. We don't need to understand each and every criteria, but broadly you can remember that you can get yourself registered as a citizen of India if you have some association with person of Indian origin, or you are either you are married to someone of having Indian citizenship. So the next criteria is same only, married to Indian citizen and residing in India for 7 years, then you can get yourself registered as citizen of India. So for registration, you need some sort of Indian origin association. Now let us understand how you can acquire citizenship by naturalization. Naturalization happens for foreign nationals. Registration process has less number of years in criteria. For naturalization to happen, the expansion or the number of years increases. So foreign nationals, not necessarily of Indian origin, can acquire Indian citizenship through the process of naturalization. Citizenship Amendment Act of 2019 ease out this naturalization process for refugees coming to India from countries like Pakistan, Bangladesh and Afghanistan. So Citizenship Amendment Act ease out the criteria of naturalization. It reduces the number of years people need to spend in India to have this citizenship. There are various terms and conditions to it. Few of them I have listed here. The person needs to have good character. The person needs to know the language which is mentioned in the 8th schedule of the Constitution, and the intent of the person needs to be to reside in this territory. So there are some criteria for you to be naturalized as a citizen of India, but this has been done in the past, and we'll discuss it furthermore when I discuss with you the Citizenship Amendment Act of 2019. There is one more criteria left for acquisition of citizenship, which is incorporation of territory. If India acquires territory, then it needs to decide on who will be the citizen of India from that territory. We have done it in the past. For instance, for Pondicherry, we have given citizenship under this criteria. So foreign territory acquired by India needs to have some citizenship rules associated with it as to who will be considered as citizen of India, to whom you should give the citizenship. So with this, we have come to the end of this session where we have discussed about the constitutional provisions and the parliamentary law associated with citizenship. The parliamentary law also talks about the renunciation of citizenship, as to who will, how can you terminate your citizenship or how can you give up on your citizenship. So we'll discuss that in the next class. Uh, Hopefully you find this session informative and you have gained something out of it. If you have any other doubts, do let us know in the comment section, and please like, share, subscribe to this channel. Thank you.